We will now leave the Deputy Minister of the Second Environmental Court, Daniela Ramirez, who will offer us some words of welcome. Good morning to all. I would like to thank you once again for your presence here today. I'd like to thank all our speakers and all of yesterday's speakers as well. It was a very inspiring day that will lead to much reflection. We hope that today
mucho diálogo. Los invitamos a hacer todas sus preguntas, sus consultas.
will also be a very fruitful day. We would like to invite you to ask questions on the chat channel. We're ready to begin with the UN Special Rapporteur, Ernesto Cali, who will be Francisco Cali. He is a specialist on the rights of indigenous people, also sits on the board of discrimination, and he works on the repair of victims in the internal conflict of Guatemala. So we would like to offer him the floor. Thank you, Francisco. Good morning, Minister, ministers, colleagues that are here with us today to speak about this important event. It is an honor for me today, as the Mayan culture is very important. We also thank those we could call spirits, but we call them nahuales. Today in the Mayan calendar is the Day of Authorities that apply justice in Mayan culture, and this is especially important if we find ourselves here today speaking of environmental justice, which and how it applies to indigenous people. We do not own the land. We are part of the land. We are part of nature. And I believe that this is where we start to talk about environmental justice. I am of the opinion that when you talk about the environment, you need to talk about the conflicts provoked by the environment. We also need to talk about environmental justice, and when we talk about environmental conflict, about environmental justice, we must mention the indigenous peoples and their rights, their cosmovision, their knowledge, their scientific knowledge, their relationship with nature. Environmental justice is broadly understood, and you are all the experts in environmental justice, but broadly speaking, environmental justice is a social theory that explains the experience of people who are at a disadvantage, or as a social movement that demands more equity, inclusion, acknowledgement of how the environment is used and managed in the world. And for indigenous people, environmental justice must be based on balance and harmonic living with the environment. And 80% of the biological diversity is found in indigenous territory, and they take up 22% of the planet's surface. And if we understand that the indigenous people make up only 5% of the world's population, we can say that it is they who are the guardians of biological diversity and of a healthy and clean environment, which we still have today. And there's a very special role in sustainable management of these resources, in the conservation of the environment and of biodiversity. And these are essential for the survival of mankind and the fight against climate change. Nowadays, the indigenous people have proven to be the essential guardians of Mother Nature. It's important to clarify what is development for one or another culture and how this justice system protects the interests, the economic interests of large companies and not of indigenous people. The protection of corporations or of their interests finds its arguments in the common interests of the population, which is a very vastly used argument when corporations wish to exploit natural resources. And if we mention corporations, we're talking about all the mega projects, the extraction industry, inclusive extraction, even clean energy, which basically leaves more poverty, more destruction, environmental destruction, and depletion. And it's all in the name of development. I say development in the Western world's definition. They've been working with communities. They bring more cash flow into the circular economy. But sometimes we ask ourselves, well, what about when they leave? Where is the stream? Where are those places where children used to go play, where the population, where the people used to go for water or to collect this vital liquid to use it every day in their homes' daily consumption? Today, we see privatization of water. I can't go to a river because it no longer belongs to the community. It belongs to a private company. This is something that caught my attention, especially in talking about corporations and about indigenous people being against development. But what development are we talking about? It is a development that leaves us more suffering, more poverty, more restrictions, and they are taking resources that for centuries have been maintained thanks to the care of indigenous people. Many times it is said that indigenous people are against development because they are ignorant. They are ignorant because they defend their land, their territories. For the arrival of colonists, they were expelled from their land, from the territory they used. They were sent to land that the colonists did not want, the colonizers. And all these lands are the lands where there are the greatest mineral reserves nowadays. And it's interesting when we force indigenous peoples out of their land. History repeats itself, and again, they're accused of being terrorists, and they're persecuted. Their leaders are persecuted, and it's only about defending their community, their life, their land, their territory. As of this situation, we find ourselves today in different forms of conservation. There we find those promoted by states, Western, international, and national corporations, and the indigenous people. But these conservation systems have their own rules, their own institutions, their own governance and indicators. And these sometimes supplement each other, but sometimes they're quite antagonistic. There are protected areas that are not necessarily a comprehensive protection system. If you take into account the population, many of these systems only protect birds, biological diversity, but it's not possible for this diversity to exist that way. the different visions of development, if we can call development to the increase of wealth, the privatization of water sources, the destruction of nature, the extraction of minerals, and leaving some territories unproductive, that is what is affecting indigenous peoples. And many times these social leaders warn that conservation of the biological diversity is of the utmost importance for development. And sustainable development is not compatible with the rights of the indigenous people. But sustainable development is compatible with the indigenous people. And it is of the essence in order to protect these territories, and that we don't see, so that we don't see it as systemic abuse of the land. However, building highways, building forms of communication make it easier to access these protected areas. So if we're talking about justice for indigenous people, it is there is greater access to healthcare centers. Highways are sometimes useful to indigenous peoples, but they also bring destruction. So, hence the importance of environmental justice, and we need to understand that environmental justice seeks equity. It seeks to protect those that are most vulnerable and that are protecting this biological diversity. That is, if we want to survive as mankind. And equity, inclusion, and the acknowledgement of the way in which the environment is used and managed, distribution, the acknowledgement and participation in this context, we see the rights of Mother Earth arising. They are based on the principles of balance and conviviality and living in harmony. And it is necessary to recognize indigenous peoples as such in their right to their regional autonomy. And indigenous people must create new states or smaller states, but actually it's necessary to clarify that one of the practices of free self-determination has to do with regional autonomy. The destruction of this territoriality by the states is somehow in conflict with self-determination of the indigenous people. Indigenous people wish to participate in the structure of the infrastructure of the state, but many times there's people that do not allow the indigenous people to fully participate in these state structures. This right is an internationally recognized right in human rights, and it is also subject to informal consultation, and it is a right that is directly related to the indigenous people's rights to their land and their territory. The indigenous people are being expelled from their territories. They are being exploited in the name of development and conservation. We see how their territories are being sacked and they're violating environmental rights, human rights, labor rights. There are policies being implemented that affect the indigenous peoples, like extensive crops and others. And environmental leaders and defenders are being harassed and murdered. We must not allow indigenous people to be expelled or evicted from their own territories, as well as discriminated politically, socially, and economically when it has been shown that they are a fundamental part of territorial development. You have a couple of minutes. 5 minutes. Thank you, Minister. And the use and conservation of nature for the indigenous people would be an act of justice, because these forms of governance have shown that they have been able to preserve nature, and it would be an alternative to put a stop to the negative impacts of climate change, avoiding deforestation, the lack of water, and we would also be protecting biological diversity for Mother Nature. Human and cultural resources are important in this framework. It's necessary for countries to respect this culture. It is understood as a system of rights, and today we have conservation systems which should be based on this. They must recognize indigenous territories and traditional practices, our systems of justice management, territorial governance, especially to prevent pandemics as the one we are experiencing now. Indigenous people should maintain their right to their territory, to self-determination, and those who have proven to be able to put a stop to mass contagion. I would like to stop here, and I would like to thank the authorities once again, the Chilean authorities, for organizing this important forum.
Muchas gracias.
Thank you very much.
Thank you, Mr. Kali, for your thoughts in the area of development and the needs to discuss as soon as possible about the water rights, as well as protected areas or other different technologies that are related to sustainable development. They can all have an important impact in indigenous people. We cannot consider it very light. We have to see it from a critical and autocritical perspective, and how self-determination of the indigenous people have to be taken care of. We have to think or rethink how to incorporate the indigenous people in the decision-making process. We have 3 important panels: Constitution and Environment, Environmental Principles, Judicial Experiences, and I would like to leave the floor to Magdalena, and she will be opening this. Thank you, Honorable Justice Daniela Ramirez. Now we will be working in the 4th panel, Constitution and Environment. We have Mr. Gittvinter, professor of the Law School in Bremen, Mr. Jordi Haria. He is professor of constitutional law of the Department of Public Law, the Faculty of Legal Sciences in Rovira, Virgilia, Spain. Mr. Henry, consultant of the environment, human rights. Ms. Lilian Galdames Celada, assistant professor of the Department of International Law, Faculty of Law, University of Chile. Ms. Amaya Alves Marin, and she is a researcher from the Concepcion University. This panel will be moderated by Ms. Carla Vega from the 2nd Environmental Court in this 4th International Environmental Justice Forum. Just to begin with the conference of Professor Gert Winter that was already introduced, and we had technical problems with him, but he has been kind enough to participate in this panel today. And the moderator can introduce more widely later on, but so that we can begin today, I will leave the floor to Professor Winter so that he can, so you have been acknowledged.
Okay, thank you very much. I'm very grateful and feel proud to be invited to this highly interesting conference with so many different subjects. I especially thank Francisco Carli for his presentation. This makes me really think about my own approach, which is heavily Western. And I think we have more duties to reflect on the dimension of indigenous people. So thank you for this and for inviting me. The focus of my lecture will be how effects of environmental degradation on human health are governed by the human right to health. In doing this, I will concentrate on the European Convention of Human Rights and its interpretation by the European Court of Human Rights, throwing some spotlights on the EU Charter of Fundamental Rights and its interpretation by the Court of Justice of the European Union. To simplify the talk, I will in the following call the first court the Human Rights Court and the second the EU Court of Justice. Incidentally, both courts are presently dealing with a spectacular climate protection action each. Actions that invoke, among others, the right to health and aim at more ambitious reductions of greenhouse gas emissions, involving 34 European states in the first case and the entire EU in the second. The first was brought by 6 Portuguese children and is called Claudia Duarte versus Portugal and 33 other states. And the second was brought by 10 families spreading over many countries and is called Armando Carvalho and others versus the European Parliament and Council. By the way, one of the plaintiff families in the Carvalho case is a family of reindeer herders in the northern areas of Sweden. So we do have a dimension of indigenous people here. I will come back to these actions later. The human right to health can best be explained along its 3 core components, which are the scope of protection, the kind of interference, and the possibility of justification of an interference. I will discuss them in turn. Concerning the scope of protection, many laws and institutions explicitly establish human right health as a right to life, which is, however, most often applied in cases of causing death or particularly drastic dangers for human health. Most cases of environmental degradation affecting health are decided on the basis of Article 8, which literally lays down a right to respect for a person's private and family life and home, but it has for long been interpreted as containing a right to health. It is open for discussion if the framing a person's private sphere rather limits the protection scope to only ensuring absence of disease or extends it to social and psychological well-being. Concerning interference with the right, the question arises to what extent the often complex environmental processes adversely affecting human health can be regarded as interference with the right. According to standing jurisprudence of the Human Rights Court, the right holder must be, quote, directly and seriously affected by the nuisance, unquote. In addition, the court requires that the nuisance must be actual. Let me explain the terms serious, actual, and direct, how they are understood. Regarding the criterion seriously affected, the Human Rights Court has not established quantified threshold values. It rather proceeds case by case, distinguishing situations of usual nuisances from exceptional ones, and rather working with qualitative criteria. In Cordella versus Italy, the court explained that such criteria are, quote, the intensity of duration of the nuisances, as well as the physical and psychological effects on the health and the life quality of the affected person. End of sight. Procedurally, it is of course important to submit expert reports assessing the risks. Thus, in Cordella, the court summarized a great number of scientific studies on the noxious substances emitted from an installation and the increase in lung cancer in the neighborhood. Regarding actual concern, the Human Rights Court indeed requires that the harm caused is present, although rather as a precondition of admissibility than as a component of the substantive right itself. Anyway, more recent judgments have accepted allegations that the damage will occur in the future if there was high probability to that effect. Regarding the criterion directly affected, the cases brought to the Human Rights Court have rather been of a kind where the plaintiff's suffering was an immediate effect of polluted environmental media, and less frequently, the underlying causation between emissions and their concentration in the environmental medium. If such causation is straightforward, it is relatively easy to assess by the court. This is more difficult when the causative processes are remote and interwoven. One important field posing that problem is the production and marketing of dangerous products. Taking risks from pesticide residues in food as an example, evidence must first be collected on the causation of a disease by consumed products. Second, and further backwards, on the causation of pesticide residues by one or more candidate pesticides. And third, on whether involved actors have made proper use of the product, such as whether farmers have applied the pesticide according to instructions, consumers have not excessively consumed the contaminated food, etc. In sum, it will often be impossible to establish that a specific product of a specific producer was finally causative for an observed or predicted disease. It is likely that those longer chains of causation will be classified as indirect, with the consequence that the court cannot order the state to regulate the pesticide. As this approach is also common in other legal orders, dangerous products almost entirely escape judicial review in terms of the right to health. Climate change is another example of remote and interwoven causality. Does the subjective right to health include a right to, say, the setting of more ambitious greenhouse gas emission reduction targets, and even the taking of specific emission reduction measures? After all, the causal chain from greenhouse gas emissions to damages is very long and complex. Greenhouse gases concentrate in the atmosphere so that increasing parts of solar radiation are not reflected into space, thus causing the warming up of surface temperatures. By certain intervening processes, this disturbs the thermohaline ocean and the atmospheric wind circulations. As a consequence, extreme weather events increase in number and strength, sea levels rise, and identifiable world regions are exposed to flooding, droughts, and/or heat waves. This causal system of interaction is almost unanimously agreed upon by scientists, societies, and policymakers. Is it also, in the legal sense, directly affecting individual persons? The Human Rights Court, if applying the traditional directness test, will most likely deny this because so many factors intervene. But there are reasons for changing this tradition. Causality must be construed differently for public and private responsibility. More ambitious requirements to prove causality are justifiable for private law rights against polluters because here two rights holders litigate on an equal basis. It should be noted nevertheless that even in private law, an alleviation of the burden of proof has been introduced in unequal situations, namely concerning liability for large, dangerous installations and products. Concerning public law relations between private persons and government, it should be considered that public authorities are mandated to oversee also long and complex chains of causation. The subjective right to health should therefore be construed to also trigger public action that tackles remote and complex causes, provided sufficient evidence is available. The principles of abating damage at source and of precaution come in here and may be construed to allow right holders to rely on them. I therefore suggest that the Human Rights Court should replace directness by likelihood of causation, considering also a reversal of the burden of proof in case of prima facie evidence. This means that judges assessing causation must work themselves into pertinent sciences and their empirical and modeling grounds, but they must also maintain a sense of independent judgment. Luckily, complicated systems may sometimes be treated as black box if the correlation between input and output is settled knowledge, such as between, let's say, a centimeter of sea level rise as related or caused by a number of tons of emitted greenhouse gases. Remarkably, the Duarte and the Carvalho cases raise that very issue, while the EU Court of Justice, since 2.5 years, lingers with admissibility issues, the Human Rights Court has shown willingness to pursue new ways in procedure and substance because it classified the application as urgent and invited the defendant states to comment on procedural and substantive matters. Once causation of health impairment has been established as a de facto interference, interference has also a normative dimension in the form of responsibility for the causation. Government can be responsible for interference by action or omission. The corresponding right is called negative if shielding the right holder against governmental action, and positive if alleging omission and claiming protection against harm caused by private actors. The Human Rights Court has derived both negative and positive rights to health from Article 8 of the Convention of Human Rights and does not see much doctrinal difference between the two. I doubt this. I see a difference in at least two regards. First, the negative constellation implies that where a constitution establishes a so-called legal reservation, The state must base its interference on a law. If there is no legal basis, the court may do with rebuking this as a formal failure with which courts anyway feel more comfortable than if asked to take a position on a substantive issue. Second, arguably, in the case of positive obligations, the discretionary margin of the state concerning measures to be taken is broader than in case of interferences, because the political field is wider open than if a specific measure has already been taken. If negative and positive rights make a difference, how can interferences by action and by omission be identified? A clear interference by action, by governmental action, would be, for instance, emissions from public infrastructure, and interference by omission, unregulated air pollution from industrial installations. But how is a licensing scheme for polluting industries to be classified? Traditionally, it is regarded as emanating from an obligation to protect, but the permit implicitly requires neighbors to accept residual pollution. Likewise, in the Carvalho case, it was submitted that the greenhouse gas emission allowances allocated to actors by the EU Commission are to be construed as action, interfering with the right to health and other rights of affected persons. I now turn to the third component of basic rights, the justification of interferences. While the first paragraph of Article 8 establishes the right to health, the second provides for the possibility of justifying an interference if this is necessary in the public interest or for the protection of the rights of others. The Human Rights Court construes the relationship between the two sections as a weighing up exercise, suggesting that, quote, a fair balance has to be struck between the competing interests of the individual and of the community as a whole, unquote. I have some doubts about this concept. It downplays the fact that a basic right is first of all a right against interferences, and that a justification of those can only come as an exception, which, according to general legal doctrine, must be construed narrowly. When looking for justifications as a first step, a public interest or basic right of others must be identified. One should not take that step lightly. In the context of litigation, of climate litigation, for instance, one may question if the production and use of large passenger cars, notably SUVs, is at all in the public interest or covered by basic rights of car owners. Once a legitimate public interest or affected human right of another person was found, the necessity of interference must be tested as a second step. This opens up the consideration of alternatives. In that line, in the Carvalho case of the EU Court of Justice, it was alleged that the EU Commission failed to undertake an in-depth study exploring the best emission reduction targets that are technically and economically feasible. There are two more tests that come in if necessity, in the sense of Article 8, is understood as proportionality. One further component is that the interference must be capable to reach the legitimate objective. That could be called the capability test. And the other, that its adverse effects must not be out of proportion in comparison with the importance of the objective. That could be called test of proportionality in the narrower sense. Proportionality in the narrower sense is not just an open balancing of concerns, but the test of a mismatch of weights between the interference and the legitimate objective. The proverb demonstrating this is, "Don't shoot with a cannon on a sparrow." An illustration more to the point would be that we risk tremendous damage to our health and environment just for the sake of many luxuries of the Western lifestyle. In other words, the damage is unproportionally high compared to the comforts of consumerism. Concerning the capability test, this is often overlooked, but sometimes constitutes a short way out of further digging into justifications of interferences. For instance, emissions caused by traffic congestions do not even serve the otherwise legitimate objective of bringing people to workplaces and back home. They are, so to speak, nonsense interferences. The assessment of legitimate objectives and the proportionality of means is often confronted with many options. This is particularly evident when it comes to study alternatives that can minimize or avoid interferences. In reaction, the Human Rights Court and as well as the EU Court of Justice acknowledge a margin of discretion into which the judiciary should not intervene. The limits of that discretion are circumscribed by terms such as arbitrariness, misuse, underuse of powers, but that does not help much. Normally, it is a closer scrutiny and understanding of the facts of the case that generate appropriate criteria for a well-reasoned decision.
Professor Winter,
Yeah,
you have 5 minutes.
Well, thank you. Summing up, I tried to sketch out the structure of the right to health as laid out in the European Convention of Human Rights and interpreted by the Human Rights Court. If I was asked, what is your take-home message? The answer would be, first, that new criteria are needed to draw remote and interwoven causal chains endangering human health into the ambit of the human right to health. Second, that differences between interferences by action and omission should be recognized. And third, that interferences should only be regarded as justified after very careful scrutiny of public and third-party interests, as well as of all three components of the proportionality of their pursuance. Thank you very much for your attention.
Thank you for being here with us. Tomo la palabra nuevamente como moderadora de este cuarto panel.
Let me go back to my role as the moderator. Let me welcome those of you who are joining us through the streaming of this fourth forum, and particularly our speakers, along with Professor Winter, who are with us today on our fourth panel called Constitution and Environment. Before introducing the rest of the presenters, I want to explain why we've included a topic of constitution and environment on a panel here. Given the current constitutional environment in Chile, we are checking with an issue with the entirety of human beings, the relationship between people and the environment. Since the Chilean Constitution took force in 1980, we have seen, in fact, that there is the right to a clean environment and an action to safeguard that right. To date, however, the understanding of that relationship has changed significantly. So far to date, a variety of constitutions, including Bolivia and Ecuador, have included nature as an object of and subject of law, as an understanding and a way of understanding the environment that surrounds us. In fact, the understanding of nature as a right holder has to do with the role of men and women as we interact as humankind with them, as well as a new understanding of what are considered to be commonly held goods, such as air and water. The negotiations in Chile that are currently underway involve not just legally protected goods, but also philosophical and other values. That is why on this fourth panel, we will be sharing with well-known experts who will contribute to this discussion. At the end, of course, we will have an opportunity for a question and answer session. Those questions can be posed through the forum website under the streaming of the forum in English and Spanish. The questions will be selected during the presentations and will be posed once all of the panelists have concluded. Following the remarks of Professor Winter, we thank him again for joining us today for this panel. Let me introduce Professor Jordi Haria Manzano, who is a professor of constitutional law of the Department of Public Law and the School of Legal Sciences at the University of Barcelona. He also holds a master from the Universitat de Rovira i Virgili, as well as a role in environmental law. He has written a number of presentations and papers on this topic. Currently, as I said, he is a professor of constitutional law at the University Rovira i Virgili in Spain. Jordi, thank you very much for joining us, and I would like to give you the floor for your presentation. Thank you very much, Carla. Thank you, of course, to the organizers for the pleasure of allowing me to join you and come back to Chile, albeit virtually. It is a pleasure to share with you some thoughts, particularly at a time that is so exciting, as you have noted, because, and in addition, it's always a pleasure to be the guest of the Constitutional Court of, the Environmental Court of Chile, but it's also a tremendous responsibility to share with colleagues who are so renowned and to, in that context, have an opportunity to learn from such esteemed colleagues. I will endeavor to present, I would say, not so much conclusions, but rather to pose some questions regarding recent research, and I will endeavor to relate that to the ongoing Constitutional Assembly process in Chile, as well as the role potentially of the court, specifically the Environmental Court, in the context of the potential result of this process. I would like to divide my remarks into 4 parts. First, I will address what I perceive to be the mainstream of the idea of constitution in the current evolution. Second, I will address some questions or potentially objections to this hegemonic understanding. Thirdly, I will address some of these doubts vis-a-vis the codification of uncertainty. And fourth, I will conclude noting the role that a national constitution may play in the transformation of the world that we are currently experiencing. To commence, I'm going to start from the baseline that, in effect, there is a growing trend in the literature in terms of what is happening worldwide. Given time constraints, I would posit that we are in a process of anthropocenic change, as we've seen as a result potentially of the seminal work, which is Geology of Mankind in 2002 by Paul Kuch, the Nobel laureate in chemistry. And in this context of environment versus earth and anthropogenic change, given the world of natural sciences, we have seen how social sciences have picked up on these concepts, starting with political science, with the idea of system governance for the earth, including Professor Fran Berman and others. Works by Rachel Kim and Lukom Sim, among others, have also helped to develop the idea of system law that reflects this anthropogenic law. We might say that this approach seeks to use ideas, thoughts, beliefs that had been set forth previously in what was known as global constitutionalism, a theoretical approach that starts on the basis of the constitutionalization of international law, very much inherent to the European tradition that links, as Professor Gert Winter has just said, in terms of the European courts and the shared constitutional systems. Europe is a good example, but of course there are others. So based on these grounds, this foundation of global constitutionalism, we saw an interpretation of what constitution should be that would be therefore allowing for a twist to this to allow for the interactions between Mother Earth and human beings. In any case, I would not debate the traditional interpretation of formal normative constitutions when we move to the global stage, although there are arguments to support such a change and to manage this geological change that has been induced by human beings, and to see how all of this might be managed by the human beings who've caused this change. Of course, the tradition in the Western world is one of a constituent power for a normative constitution, and certainly this reflects the Judeo-Christian tradition, of course, the role of God, and the Constitution is then this biblical pact to a certain extent that does a couple of things. It codifies a series of behaviors, and so it's a political code, but at the same time, it includes a promise of redemption, a secularized redemption that provides for these constitutional rights, including economic rights. So I don't want to focus on the rights side. Certainly, we need to address this in the context of the challenges posed by the changes in the planetary level, but also the changes in coming from non-Western sources, and particularly in, as was noted at the beginning of this session, the perspective of indigenous peoples. I am not going to focus on that, but I'm going to look at a constitution as a program and the constitution as a code. So to a certain extent, the idea would be that we would see this architecture posed by the Constitution, including a series of behaviors and conducts which endeavors to ensure that there's a reflection of the original power, the constitutional power, and that is what we are experiencing in Chile. Of course, starting with a plebiscite last year, the people of Chile have agreed to create a new form of social and political harmony, establishing a new system, an improved version, so to speak, of the Constitution of 1980, of course, which emanated out of the Chilean dictatorship. Obviously, there's a proposal to create something similar, but planet-wide. Now, to the extent that we can refer to it, the current pandemic is also forcing a number of planet-wide changes caused, again, by human beings and their interaction with nature. If we look at this from the Anthropocene and we assume that to be a proper approach, while I'm not going to delve into it, I could summarize it by saying that the new geological era that we as human beings have contributed to causing interact with our own past and that of the planet. Therefore, we are grappling with a planetary system characterized by three things. One is the comprehensive nature that it is a global change. Second, that change is irreversible, which corresponds with the second law of thermodynamics. And the third is that, what I want to focus on in this third part of my presentation, and that is uncertainty vis-a-vis these changes. Literature and the most recent literature with regard to Anthropocene suggests that human beings have created this planetary change, this geological change. Human beings are therefore and they have led to conditions that are beyond our own control as human beings, and therefore creating non-linear disruptive events. These non-linear disruptive events are inherent to complex systems. I'm sure that all of you are familiar with the metaphor of the butterfly effect, which is, of course, the explanation, an allegory, we might say, to a climate model of the 1960s. And I'm sure you're familiar with the butterfly effect. And of course, this creates, as a butterfly flaps its wings in one part of the planet, it creates a disaster on another. So these non-linear disruptive events are the extreme climate events. And we could consider that this global pandemic also could be associated with a loss of biodiversity, climate change, and obviously has had a much greater impact in these types of episodes, not just this one, but also these types of diseases that make the leap from the animal kingdom to human beings. The 2003 original SARS, the swine flu, H1N1, and others, as well as MERS, and 2012, the respiratory diseases. So in any case, this pandemic is part of this process of global transformation and puts us in a situation where we do have a nonlinear disruptive event. And in the context of our constitutions and all of our liberal democracies, there has been a reaction by the institutions through the application of the law of exception, which suggests that our regular codified law is not able to grapple with. That's the basis of laws of exception. And we're seeing that there is a need to return to a call to return to normalcy. But if there is no return to the old normal, then we need to understand that our Constitution as a standing code, with its effort to create this consensual political and social harmony over the long term needs to be updated and therefore to be sustainable over time. So then we get to the question, to what extent can we codify uncertainty? And this dovetails with what is happening in Chile today. What we're seeing is a proposal to modify this means of political and social harmony, moving from a traditional American democracy looking toward a US or a French-style revolution to a certain extent through the plebiscite, creating a constituent assembly to start from scratch and therefore craft this model for political and social harmony into the future. It's as if we were to go back to 1789 or 1776, a constituent assembly that from scratch designs a system of governance and social harmony. Now, clearly there are significant challenges there in terms of trying to have a constitution codifying this type of harmony, given the future that is clearly highly uncertain. From the realistic perspective, the question is, what sort of autonomy does a constituent assembly have? I don't want to delve into that, but I do want to mention it briefly just to, with a view toward wrapping up. And the question then is, what role can a national constitution play in terms of environmental protection vis-a-vis global processes that are far beyond the scope and the ability to manage of an individual state, plus the uncertainty we are experiencing today and future uncertainties, unknown, of course. And this leads me to pose the idea of having a constitution that allows us to devise strategies to encourage dialogue, texture, evolutionary, fragmentary constitutional approach that to a certain extent is intertextual. In other words, it's not just the Constitution that is the be-all and end-all that creates legal certainty into the future, but rather it is a living document that allows us to create strategies for grappling with future uncertainty in a complex future. Independent of the architecture, I would expect that the constitutions of the future would have a lot to do with principles and opportunities for dialogue that in a place such as Chile, and going back to what Francisco Cali has said, should endeavor to create spaces for communication and particularly with non-Western cultures, in Chile specifically the Mapuche people. That is certainly a long-standing discussion. We're not going to find a solution to this today or even the coming months or perhaps even in the coming years. But certainly we need to see a progressive change in our understanding of what we mean and what we understand by the concept of a constitution. And in some constitutions should, I believe, less be some sort of sacrosanct book of a strictly normative nature, but be a provisional space for understanding. And as a provisional space for understanding or for consensus, or the building or forging of consensus, better put, this is where the courts have a fundamental role to play. This also involves challenges to the judicial process, consensus that is generated on the basis of individual texts that we have before us, and the formal constitution is certainly one, but not the only one. And then we need to generate these provisional points of consensus through judges that have a certain authority vis-a-vis the public, specifically the courts of law. And this means stepping out of our comfort zone in the formalist positivism, looking at law as the codified will of the people that the judge specifically just interprets and applies in a specific case, but a means for a much more active role, but also a much less authoritarian role of the judge in generating what at the end? Well, given the processes that we are grappling with, the closer we can be to a more resilient, inclusive society. I think that would be the end goal. And this is tied, of course, to environmental justice. The idea being that given the uncertainties of the future, it is important to maintain resilient societies, and resilient societies must be inclusive, sine qua non. So therefore, it seems to me that the linkage to Earth-based systems and maintaining human life as we know it on the planet is intimately linked and can only be done as only desirable if we can also ensure inclusion, particularly of the most vulnerable populations. So therefore, in my view and in conclusion, what I would say is this.
En este momento histórico, la elaboración de una constitución
At
formal.
this historic time, it is extraordinarily attractive and interesting to see the construction of a formal new constitution. But I think to be truly effective, Chile needs to step outside the comfort zone of such a constitution and envision the future. I believe that a formal constitution must offer opportunities to create dialogue that is always open, provisional, fragmentary, that allows us to respond to the events that are being, our interactions with basically with Mother Earth and Earth-based systems. I believe my time is up, so I will stop on that note. And I will now listen attentively to all of my colleagues, and I look forward to learning from them tremendously.
Ahora, bueno, vamos a dar
Thank
paso.
you, Jordi, for your presentation. Very interesting. I'd like to offer the floor now to Henry Jimenez Juanipa. We thank you again for being with us at this forum. He's an attorney of the Santa Maria de Caracas University in Venezuela. He's a specialist in criminal sciences from the Catholic University Andrés Bello in Caracas, and has a master's in law from Heidelberg University, and he's a doctor in law from the Hudoku University in Germany. He has published several documents and is a consultant on energy, environment, and climate change. Henry, you have the floor so that we can hear your presentation. Hello.
Perfecto. Bueno, ante todo, pues, muy buenos días.
Well, first of all, good morning to all the participants. Thank you, Carla, for your generous introduction. I'd like to especially thank Dr. Cristian del Piano for honoring me with participating in this 4th International Forum on Environmental Justice that is being carried out very successfully. I'd also like to thank our colleagues, the ones that preceded me and those who will come later on today. We are certainly learning a lot from each other. So my presentation will be about the rights to access within the framework of Escazú as a part of the Jus Constitutionale Comune, or common constitutional law for Latin America and the Caribbean. I'm going to divide this talk into three parts. A brief introduction to put all this into context, a reference to the rights to access as a nucleus for the Jus Constitutionale Comune, and a third part on the desire for these reflections to somehow be useful to this intense debate that Chile is undergoing, to have a constitution that will somehow reflect the claims, demands, and historical moment that we are living, as Jordi explained before. So in environmental human rights in Latin America, we see that we are lacking. This corpus juris has been built since the previous decade in the hands of the right to access to information, to participation, and to environmental justice. And in this region, we have seen it favored by jurisprudence and doctrine. On the other hand, given the ratification of the Escazú Agreement on the access to information, public participation, and the access to environmental justice in at least 11 countries for the environmental protection and for those the protection of rights of persons, there has been a standardization, a harmonization of this Jus Constitutionale Comune at an environmental level that facilitates the participation of citizens in the defense of the environment and of human rights thus associated, and therefore represents a challenge to environmental justice. However, all debate on the efficacy and compliance of the Escazú Agreement are only beginning to be understood, given the it has not yet into effect, and there are doubts of countries that have not yet ratified Escazú regarding the degree of protection or the standards that this would, or how this would bind those who have ratified. In the Latin American region and in the Caribbean, the protection of the environment and of human rights, therefore associated, are bound by the Constitution, because the Constitutions so included, and because the International Court of Human Rights has determined these rights and protections, or because they've ratified the Escazú Agreement. This is constantly being supplemented and drafted under a multi-protection level of human rights reinforced by compared law. The Escazú Agreement stresses the Jus Constitucionale Comune Ambientale in Latin America and the Caribbean. And in this sense, it's important to mention that at a constitutional level in the region, at least 15 countries have a catalog of rights that includes the right to a healthy environment that is healthy and balanced. Brazil, Argentina, Costa Rica, Chile, Ecuador, Jamaica, Mexico, Nicaragua, Panama, Peru, Dominican Republic, Paraguay, and Venezuela, all included. Others, such as Antigua and Barbuda, Guyana, St. Vincent and the Grenadines, St. Kitts and Nevis, St. Lucia, and Uruguay, although they do not include the right to a healthy environment in their constitutions, they have, however, ratified the Escazú Agreement, which somehow resolves this lack, given that it is an international treaty. Now, this Jus Constitucionale Comune Ambientale has been strengthened by means of legal decisions that have been emblematic and inspiring, that recognize the relationship between a healthy environment, health, human rights, and that also demand a greater commitment to reduce the greenhouse gas effects. For example, the judgment of the Supreme Courts of the Netherlands against the state. And within the inter-American context, the Inter-American Court in Consultation 23 in the La Cajona case has established the right to a healthy environment as an autonomous right and has developed a relationship between the environment and human rights. At a national level, we can mention the judgment of the Argentinian Supreme Court decision under Pacul in the municipality of Beljarano, who ratified the Entre Rios judgment of 2019 that omitted the considering the right to living in a healthy environment. But the court ratified that the state guarantees the right to sustainability, prevention, caution, and reason in this intergenerational, progressive, and responsible principle. These principles are also contained in the Escazú Agreement, and they're very important when we talk about the constitutional debate in Chile. So participation and justice in environmental matters have as a foundation Principle 10 of the Rio Declaration of the Second Summit on the Earth, which in 1992 calls upon the parties to defend the environmental human rights. Europe and part of Central Asia also adopted and ratified the Ares Agreement in 1998, which entered into force in 2001, becoming the first international treaty that is legally binding, that guarantees the right to access to environmental rights, and it became the first treaty that guarantees health and welfare of present and future generations, and is showing significant advances both in doctrine and jurisprudence. In Latin America and the Caribbean, 20 years later, under the auspices of ECLAC, you may recall that on March 4th, 2008, 24 countries in the region, led by Chile and Costa Rica, adopted the Escazú Agreement on the access to information, participation, and access to justice in environmental matters, which was rejected by Chile, perhaps the most important promoter to that point, to the extent that the agreement was initially going to be called the Santiago Agreement. In most countries, there is a constitutional norm, and there is a positioning in this sense, given the OAS's promotion of a model law for access to information and the contributions of the Inter-American System of Human Rights. If this corpus juris, although this corpus juris offers a coherent normative body, because of course each country has its own legal visions and traditions which are sometimes not friendly towards the environment, a part of the Inter-American Convention protects this and has jurisprudential developments that take into account Jus Constitucional Ambientale. And Chile received a negative ruling in a case of Reyes versus Chile because the state did not surrender the information required for a deforestation project that would have significant impact on the environment. Along the lines of this argument, I would like to cite as well the case in Argentina, the Fundación Ambiente Recursos Naturales case versus some government oil production, and they immediately recognized the access to information in environmental matters regarding the activities that were being carried out by YPF in Yaca Muerta, and they had denied handing over information on their activities, stating that they were a private party or private company and did not have to do so. So the environmental court use this as its first case within the framework of the Escazú Agreement. It's important to mention that the scope of access to environmental information offered by the Escazú Agreement in Title V, where the member states can guarantee the access to the public of their right to environmental information. It needs to be under their custody, or it also develops the reach and establishes the assumptions of denial to surrender information and others, becoming the one legal instrument that offers the best substantive and procedural guarantees to guarantee access to environmental information. Now, regarding the access to participation, a study produced by ECLAC in 2008 shows us how the access to this right continues its growth curve. It has been granted in the institutional level. Colombia, Venezuela, Bolivia, Brazil, Chile, Colombia, and Honduras have enacted laws on public participation. Although they are not specifically environmental laws, they recognize the right of citizens to participate in public affairs. In Mexico, Law 12,871 of Brazil as well, they all have mention in their laws to mitigate climate change. The laws in Guatemala, laws in Honduras also promote citizens' participation. These are all legal advances that have been expanded in the Escazú Agreement. In fact, there is mention to how every member state will guarantee the access to public to information, updates, reviews, all matters relative to projects and activities that may have a significant impact on the environment, including those that affect human health, taking into account the national legal frameworks and international laws. Now, regarding access to justice in environmental matters, we see that the Escazú Agreement, as a binding legal instrument, also stresses this right. It is about a guarantee that is contained in the principles, the Inter-American principles, meaning in the Inter-American Declaration of Human Rights and the San Salvador Protocol, and in the Inter-American Public Order developed by the Inter-American Court of Human Rights, as well as the jurisprudence of the Inter-American Human Rights Court, and of course, in some other national legislations. Escazú exists within the framework of the different national legislations, and insofar as they can offer access to this information and to be a part of the procedure to impact any decision or omission related to access to information and public participation in any decision-making processes regarding the environment, as well as other decisions, actions, or omissions that may negatively impact the environment or contravene legal frameworks related to the environment. However, we are aware that access to justice in a region with such profound inequalities is an aspiration that may be disappointing. Phenomena such as the legalization of politics, and it basically creates a lot of pessimism in the more vulnerable sectors of society in terms of the efficacy of the courts and of expecting justice out of them, which should be a right. There are other failures in the system in the management of justice. And this is why Escazú offers procedural guarantees that seek to minimize these issues in unreliable systems that need very necessary transformations. Every party, considering its circumstances, will have its own institutions with its access, with specialists in environmental matters, efficient and effective procedures that are public, transparent, impartial, and cost-free, legitimizing the defense of the environment, the possibility of having measures to prevent, mitigate, and restore damage to the environment, measures that will allow facilitating the production of evidence when necessary, and also the principle of intention of the burden of proof is part of the agreement, mechanisms for compliance and timely implementation of any measures, and of course, restoration in the event of damage, compensation or payment of compensations, guarantees of different sorts. In the medium and short term, we also find economic barriers, the professional fees, the cost of specialists, environmental impact studies, the imposition of other costs, other procedural costs. These are all part of the list of elements that may become impediments for for people and for NGOs to have access to all this information. And of course, we would be remiss not to mention all threats to defenders of the environment, and Escazú seeks to guarantee a safe and adequate environment so that all these parties may act without threats. In Latin America and the Caribbean, we have evolved the drafting of the Inter-American human rights system, but it requires systematization. It needs to be organized, and so that there are equal conditions for all, for the environment and for citizens, that they all be protected. And this can be done through the Escazú agreement because its implementation strengthens the implementation of international standards by strengthening and increasing the influence of citizens to these guarantees, and in order to promote control measures, and also the environmental standards that have been established at an international level, such as the Paris Accord on climate change. Second, regarding the health of people and the future generations, they will depend increasingly on the role of judges as key players. Their influence is noteworthy by means of high impact judgments in different regions of the world. The implementation of public policies in accordance with the challenges and commitments made by the states are also of the essence. And finally, the role of NGOs and civil society in order to defend and protect the environment, as recognized in the Escazú agreement, will also have a key role. However, this does not guarantee the access to justice without restrictions or barriers, as we have presented. Beyond that recognition, we will have to face resistance by economic and political bodies that are contrary to the protection of the environment. That is all. Thank you very much, and I'm open to any comments or questions you may have.
Thank you, Henry, very much for his incredible presentation. It is very clear to us what he presented on the Escazú agreement and access to information and participation in environmental justice. I would now like to offer the floor to Liliana Galdames Celade, our next presenter. She holds a license in legal sciences in University of Chile and Valladolid University. She is now the assistant professor in the Department of International Law at the Faculty of Law, University of Lecce. She is also researcher of human rights of this university and has stood out in publishing different studies in environment, constitutional right, and Liliana, thank you very much for being here with us, and I would like to offer you the floor so that you can start with your presentation. Thank you very much. Greetings to all of you. It is an honor to share with you this space, and I would like to thank Honorable Justice Cristian del Piano for this invitation to this second forum and to promote this area of discussion that is so important here. When I thought about what talking about, it would be two aspects. One is a balance of what has been done nowadays in the Constitution of the 80s and the environmental aspects, the difficulties that exist in the implementation and the limitations of this area. And in a second aspect or presentation, to be able to present some proposals of the environmental dimensions of the future constitution. I have to express, and this is not a minor issue, in searching for knowledge or in systematizing a subject, we usually approach certain views from other sciences and even other disciplines among this area. And in this search, I have been moving towards an interdisciplinary work. So part of what I will be presenting is related to the work that we are doing in a network. It is an ecologic constitutionalism network. We have historians, geographers, biologists, lawyers, philosophers. So it is a wider range of disciplines, and it will be very interesting to participate in this reflection. In the first part then, I would like to talk about the way in which the Constitution of the 80s is dealing with the environment. And we all know that the Constitution incorporated something that was related to the matter, Article 1908, considering a fundamental right of living in an environment free of pollution or contamination, duty of protection, the protection of the state to the nature, and a clause of restriction of rights that allows the legislator to consider rights that will mean protection of the environment. And this fundamental right is ensured by a protection recourse that is related to this area. There's no more in the Constitution about this. And there are many studies that include the analysis of other dispositions. And of course, this is related to the environment as the use of water, everything that is related to mining and that have to be part of this environmental dimension. But here I will be mainly focused in the fundamental right of living in an environment free of pollution and the contents that the Constitution is presenting, the Constitution of the 80s. Coming from the theoretical study of the standard comparative law of the other areas, and knowing about these protection clauses, we have reached a conclusion, and we have talked with the ecologist Barbara Saavedra. We reached the conclusion that law does not consider nature. This does not consider biodiversity, and it is a basic hypothesis to understand where are the problems of the Constitution of 1980. We first would have to say that in terms of the Constitution, if there is a way to understand nature in the Constitution, I would say that one of the ways in which this is understood is it's more of an aesthetic view. It is more classic view that really belongs to the first part of the 20th century, which is to consider the beauty of the landscape. It is not so much as this, but in those discussions that are from the Ortúzar environment, which was, of course, a pioneer when incorporating this nature. The beauty of the landscape is important in terms of protecting the environment. And the second important element that belongs to the concerns of the 18s, and it is around this area when there is a discussion of this area, and this is pollution of rivers, of the atmospheric pollution, and other problems that even though there were publications already, and the Ortúzar Commission was saying that there were concerns related or expressing international agreements that were talking about an important tension between development and protection of the environment. There was an important tension between the impact of the environment and others, but it is not considered in the Constitution. So these fundamental rights to live in an environment free of pollution, understanding the word environment, and I would really make it more tangible, starting from what the what case law says, and it is related to this idea of an environment free of pollution. And the environment has been considered as all areas, any area in a specificity, which is the adjacent environment. It is a concept that Bermudez installed when talking about a fundamental right to live. There has to be a relationship, a material relationship between the person and the surroundings, being this surrounding an adjacent environment. So how do I take it into practical terms? There is a case of an organization of civil society that is considering the rally going in the north of the country, where this NGO is in Santiago, and the court does not consider active legitimacy of this NGO to go to trial for something that is up in the north of the country. It is not the adjacent surrounding where they are placed or located. So understanding the fundamental right to live in this environment is, by definition, in the Constitution, it's an individual right. It's an anthropocentric right. It is the right of people to live in an environment, as I was expressing, free of pollution. And the concept of free of pollution has been taken and developed in the ordinary case law and even in the Constitution, coming from the 19,300 law, which is defining an environment free of pollution. And we can say that this is a mistake when we're talking about the Constitution, but the law does not link it to the constitutional contents. It cannot limit it. And the law, again, this idea free of contamination is really linked to the right of health. How much the contamination or pollution indexes can affect health. And if there is something considered in terms of health, then we would be talking about this type of protection. But from the perspective of active legitimacy for these protection appeals and that are of individual nature, that do require the environment to, or the adjacent environment to be able to go to court, has generated a jurisdictional response that has been adapting itself to the different challenges, considering what the environment needs, generating interpretations that are even establishing different presentations of this idea. For example, accepting the disputes or collective actions towards the environment when somebody that is here presenting, for example, a municipality is disputing this as representatives of the neighbors. It's like a fictional activity that they can appeal on behalf of others, but I have to understand and accept who is these others. Now, again, where is this case law trying to work in this area, and that it is considered or seen when, for example, the ordinary case law is requiring from the Constitution that this is coming from a specific person, and case law again has understood that if I am a neighbor of an irrigation stream that is contaminated and meters away from this stream, there are different industries. I can mention all of them as being responsible of the damage, even though I don't mention it is industry 1, 2, or 3, but the court has accepted this type of presentation to court. Now, the other two dimensions is the duty of the state to preserve nature and the clause of restriction of these rights. I would say that from the perspective of the case law, I think that ordinary activities have been doing some activities to be able to consider preservation of nature as an element that could mean that I can go to a court and present an appeal. It is like a reconstruction of this idea. And just to finish with this sort of balance, this very express balance, and please, I don't want to bore you. This is why I'm doing it like this. We could say that what is included in the Constitution belongs to the 80s. It's very classic. It's very old. It is focused in the area of the relationship between people and surroundings from an individual perspective that considers a subjective right and not something else, not even considering biodiversity. So now I would like to go to the second aspect. What could we think about this future constitution? How could we consider the opportunity that we have in the framework of this constituent process? I think it is important to mention a report of the United Nations published 2019. It's the environmental rights. It's from the beginning of 2019, and it says, unfortunately, it is frozen. And as Henry Jimenez was saying, this has incorporated the environment in many different constitutions with different formulas, with the different activities, and many of the different rights. There have been activities, and the report says that this important effort that is seen in the different countries does not today have a specific impact in the protection of the environment, or at least does not have an impact that is equivalent to the strength that has been developed nowadays in environmental protection. And the proof of this I will be following what Professor Jordi was saying. I will not be considering this diagnosis. I will not expose it, but the loss of biodiversity, we know that it's on a daily basis. I think that there is a negative counting that does not occur every 5 years, but every year rather, and that there is always something lost. Degradation of soils, climate change, and others. Water, drought, and others. So from this diagnostic, we start thinking, if there are so many organizations that were created, what is happening? Why is it that we do not obtain an impact with tangible results in the environment? And by the way, I forgot to mention something before when I was considering the balance, which is important for the future. When considering these environmental dimensions, we have the economic constitution, and it is a very strong economic constitution. We have a right of property, the right to property. We have everything that is related to mining rights without any guiding principles, and it is very far from the new constitutions, especially the Latin American constitutions consider clauses saying how are we going to understand, how are we going to develop the natural resource exploitation. And this has also been a concept that is being reviewed, and there is still no preference about natural resources in contributions of nature to people, so that we don't use the word resources. And there has been in this environmental constitution of the 80s very strong struggle between the economic constitution and the others, as it has been much stronger in the environment. Therefore, considering this future constitution, what are we thinking of? And considering the tension that is so evident between the environment and development of the constitution of the 80s, that means I would say that it is a developmental constitution that is considering a dynamic development of the economy, and of course with many different freedoms. There is a negative diagnostic in terms of the environment. There is an institutionality that is not dealing with these challenges. How to consider the environmental aspects in the future constitution? I would say that they have to be considered from now on, which is what we are talking about in this group. We hope that the Constitution has a preface, and it should be referring to the context that the community, the global community is living. There is a global interest about the environment because this is global. It's trans-border pollution and losses of biodiversity. They are all trans-border issues. So there is a very important interest in this global environment, and we have to refer to it in the Constitution as well as in Article 1st of the Constitution. I can even tell you that from Article 1st, where we are going to, I will be telling you what this is being expressed, the idea that there is a vital relationship between society, nature, and biodiversity, and is recognizing, protecting, and restoring its integrity for the present and future generations as a legacy of international justice. This is binding all of the powers and people, and the state declares the promotion of the state, understanding that nature and biodiversity are the natural source that is sustaining it, and the state acknowledges that the ancestral knowledge of indigenous people have to live together in the care of nature and biodiversity. These are pretty much the ideas under which we are working on. I would just like to add a couple of other ideas. The future constitution should, along its articles, should have a systemic view of the environment, not isolated as the Constitution of the 80, property over here, environment over there, and not only from a fundamental right, but it has to hold principles, protection duties. They should also contain rights and institutionality that agrees with these challenges, that will allow us to have a constitution that will be able to adapt to what is coming, that is resilient, that has the tools, that provides the legislator the tools, as well as the judiciary and the executive power, to approach something that is quite evident, that we will have to consider this and accept it in the following years. We have to accept the issue of the water as something very important in the future years. I hope we talk about water some more, but this is a consensus. There is no possibility of separating water with the understanding of the relationship of people, nature, and biodiversity. These are all concepts that have a theoretical, scientific, and dogmatic construction that need to be understood in this future constitution. References to water, to indigenous peoples, and a public interest action to care of the environment, that it should not be individual nature and it should have collective dimensions. The ecosystemic approach in the Constitution, and other many ideas that I would not like to mention now, but the Constitution has to deal with the challenges that we have for the 21st century. This is a Constitution that has been thought for the 21st century. And this is something that we have to install, and otherwise this condition will not be able to sustain the responses that we need for such a complex time that we're going through. And I would like to end with an idea that Haverler is expressing, related to the idea of searching for peace as a goal, not peace, as she corrects herself, of dignity, as a principle of the democratic constitutionalism, all linked to the post-war, this dignity idea. I think that the 21st century constitutions, together with these principles, should acknowledge and be able to work together with this possibility of human being, nature, and biodiversity. It is a constitution that holds codes that are ecosystemic, ecological, coherent, and consistent with the reality and the challenges that we need to approach. Thank you very much, Liliana, for your wonderful presentation.
And it is fundamental at this historic time that we are experiencing in our country to analyze what the basic content will be for an environmental component in the future Chilean constitution. Obviously, keeping this in track with the Constitution of 1980 and the case law that we have seen handed down by writs of constitutional protection. All of this needs to enlighten our thinking and principles, institutions, and so forth in terms of our constitution, and that is part of the changes that we have for our constitution. Thank you very much, Liliana. Let me recognize now Amaya Aves Marin. She holds a GED from the University of Concepcion, as well as a master's degree from Canada, as well as a BS in law from York University. She is an associate professor of the University of Concepcion and a TUM researcher. She's an expert in original peoples, water rights, and works, as I've noted, at the University of Concepcion today. Thank you very much, Maya. I know that she will also be addressing an important topic that I wanted to highlight at this point, and has been noted internationally, that is that Chile will be drafting the first constitution with a vision of gender parity, which is historic worldwide and very important for women both in Chile and around the globe. As we noted previously, this is a particularly salient topic for Amaya, and I know that she will be addressing gender parity in her remarks. Thank you, Amaya, and the floor is yours. Thank you, Carla. Let me thank the Second Environmental Court, its Chief Justice, Cristian del Piano, for this invitation. I am honored to participate in this fourth International Forum and to share the panel with such important panelists. And let me also thank Carla Vega as well. We, of course, share a common alma mater, University of Concepcion. I do have a presentation I'd like to share. Yes, you can do that directly from your screen. Very well.
Exactamente. Ahora sí. Ahora sí.
Perfecto. Bien, como señalaba muy bien.
Very well. As Carla was saying, I am going to focus my presentation on a gender approach for a constitution, nature-based constitution. This is something that we have addressed in the Human Rights Committee for a book that will be published entitled The Feminist Constitution. Generally, when we speak about these issues, and I was listening to the special rapporteur from the UN, he was speaking about vulnerable people, indigenous peoples, but very often there is no distinction made between and among who those individuals are. Therefore, perhaps it is important to ask ourselves whether it is possible to revise the paradigm of the regulation of nature in the new constitution with a view toward ensuring material equality for all persons who inhabit a given territory. Looking, therefore, at nature from the interdisciplinary approach, from perhaps biological or systemic visions of the world. But I think it's also important in this new constitution, and since the Constituent Assembly will be operating on gender parity, then perhaps we may see equal treatment and not differentiated treatment, because obviously equality is the goal. So it's not necessarily a equal treatment. We may need to have differentiated treatment nonetheless. Let me, on that note, suggest that the place that we occupy within the world is not always taken into consideration. We are on the periphery. We are on what is called the global south, and our geographic location and political tradition has been one of receiving information and legislation. We are on the receiving end of legislation that has been created elsewhere, usually in Europe, but certainly to the north. And our natural point of reference in many cases is Spain. And we have an invitation here, an opportunity, because clearly the situation that we are experiencing in terms of progress, the idea of development, has also been imported from Europe. So when the Spanish Empire conquers these lands, in part that conquest comes through the law and other cultural and religious areas, but one way of conquering is through the law. The legal regulations are the ones that come from that Western civilizing force, so-called civilizing force. Now, the current crisis and the depredation of nature has been addressed in a very prestigious publication, Science, in 2019, that refers to legal rights for nature. And Professors Chapron, Epstein, and Vicente Lopez Bao refer to the rights to nature and focuses specifically on the incorporation of indigenous peoples' views of nature in the understanding that nature itself can be a right holder. And this is why it's revolutionary. This is a complete change. We're not looking at the current constitution's approach of being geographic, anthropomorphic in its approach, anthropocentric, excuse me, in its approach, but looking at the possibility that a river, a forest, a mountain may be a holder of fundamental rights. This is a 180-degree change. It's looking at the world perhaps upside down. We know, of course, that maps represent or overrepresent territory. We know that Europe traditionally has been overrepresented in terms of size in traditional maps, for example. So if we look at this approach to law as a third world approach, as international law, we can see that much of our understanding of the law are territorialized, they're racialized, and they have a particular relationship with history, and there's a hierarchical approach, north to south. I've participated in a number of projects. I work specifically in the area of water rights, and I've taught some classes with international representatives, and I've said, give me a problem that's found in the north where the solution has been emanated out of the south, where there's been an issue, a problem that's been identified in the north, and that the scientific knowledge to solve it has come from the south. And my experience is that it's not easy, at least in law, to find examples. And that is what we're seeking to change through this explanation and this presentation. It seems to me that the new Latin American constitutionalism expressed in new documents, specifically the 2008 Ecuadorian Constitution, the Bolivian Constitution of 2009, represent a biocentric approach and represent a harmonic relationship between human beings and the rest of other beings. Understand is that they are part of a single entity. In other words, nature is no longer exogenous. We are all parts of nature, and this is not reinventing the wheel. This is not thinking of things that have never been thought of before, but it is opening up to the traditions and the learning of indigenous people. And it also means setting aside the prevalence of these quote unquote civilization. And we have the case of Trugos Yupanqui, an indigenous person who learned Spanish. And if there's a book that's been translated that refers, in which it's autobiographical, in which he addresses his vision of the Spanish conquest, of the loss of dispossession, and so forth. And we can see what the law has done is to force the indigenous people to acquiesce. The indigenous people have not only a physical existence, but also a philosophical and legal existence that was simply annihilated. What we have today, we also, part of this process of invisibility is very often to refer only to male experts. And so I try to specifically identify works by female authors. And in this case, we have Aves and Nandes Morales in 2018 identifies that extractivism is identified as Western knowledge of productivity, and it is particularly expounded upon by men. If we look at the new constitutionalism in Latin America, we can see a change. We've just recently presented a paper and we just got some very positive feedback, but it seems that Latin America is ahead of the game in this regard, because it is now from Latin America where we are beginning to see this proposal that non-human natural entities can express a will and can have interests and are deemed to be part of an equivalent system of shared and continuous life. This is an effort to oppose, for example, mining, exploitative, extractive industries. And very often what we see, and we've seen a structural judgment in Colombia, it's very unusual in Latin America, but the Constitutional Tribunal, the Constitutional Court in Colombia, has created what are called structural judgments, which resolve a legal issue based on the concept of precedent. They are considered to be erga omnes in that regard. And so this structural judgment, 622/16 of 2016, the Constitutional Court of Colombia reaffirms the existence of biocultural rights by giving joint and interdependent protection to human beings, nature, and resources. As Eliana has said, resources, that term is subject to criticism, but the court specifically noted that the Atrato River is a right holder, and therefore its protection, conservation, maintenance, and in a specific case, restoration is guaranteed. Very often we see that an obstacle to establishing the role of a right holder of a non-human entity is who will be the legal representative of that non-human right holder. And very often it is the state, and in this case it was the state in conjunction with ethnic communities. The problem, of course, is not really one of representation, but it's really the object of protection, understanding that nature becomes no longer an object of law, but as we say in Spanish, a subject of law entitled to hold rights. And the other situation in Spanish, the other issue with this judgment is that there will also be a follow-on to the judgment. This is also something that we don't have. And there was a panel of guardians that were established on behalf of the river to ensure compliance. This is extremely important because very often judgments become mere window dressing. They're just a matter of something that's been put in writing, but that have no teeth. And that is one of the important changes there. Now, in 2017, a very interesting article was published that addressed the obstacles to bringing this to fruition. And the first is this extractivism as a destination and capitalism as a religion. Now, that 2017 article that I mentioned a moment ago refers to this creed, the creed of the different peoples. And if we look at this as freedom of religion, of this creed, then it loses force within the catalog of fundamental rights. We can also perhaps consider that capitalism is also a creed. Now, I know that's a provocative statement. A professor said this to me once, and it really stuck with me as at least interesting from the theoretical perspective. Second, anthropocentrism as a cultural and thought model from the perspective of human rights. And obviously, third, the criminalization of the defense of nature. And this is also very much important for women. The photograph is of Alberto Curamil, who is a spokesperson for his community. He was given the Environmental Nobel in 2019. He could not attend because he was in pretrial detention for having opposed the construction of a hydroelectric plant in his region through the use of violence. Now, the next thing I wanted to address is ecofeminism. Perhaps the ecological crisis does not affect equally all people who inhabit a territory. And we have this proposal. Obviously, we have to analyze this, but there is a proposal in place to connect what we call the patriarchy with the definition of human nature, looking even at a criticism of the Western perspective and the Western perspective of nature and of women. So looking at women and nature and see how both may have been forced and dominated in terms of, in a cyclical fashion, being forced to give up their fruit. I think in this context, it's important to address the intersectionality between women and indigenous population, because it's much greater to see activists, female activists in the environmental issues. There are a number of issues and number of reasons for this, but very often women get involved in defending the environment as a result of their daily experiences, how it affects maternity, health of children, and other individuals who depend upon them. For example, not having water to drink, to clean, forces them into this, or pollution in their territories, or not being able to engage in subsistence agriculture because there's no available water. And we can see an indigenous woman who was assassinated for having defended the rights of nature. There are roles that are very important that women play in this regard, and that is why I believe that women are trailblazers in this regard. Could share with you, if you're interested, share with you this publication that delves into the topic in greater depth. I have two final thoughts, and those are, what can we expect from this constituent process in Chile? I think the first thing is a questioning of Eurocentrism and colonialism, that all these constitutional issues and thoughts should necessarily stem from the constitutionalism that comes from Europe. I'm sure that from the comparative law perspective, there are very interesting experiences, but as a principle, I don't think we should assume that per se, because there is a colonialism behind that idea that necessarily all good things come from the global north. I think that is a limitation, and I think we need to look at the Latin American experience as an opportunity to create new regulations, when that we have a new way of understanding human beings as part of nature, and to also take advantage of ancestral knowledge. Plural nationality will also be one of the topics of the day in terms of decentralization and management. again, protection of nature. We have a lot to learn from other jurisdictions in Latin America. And fourthly, of course, this leads us to question the development model in unequivocal terms associated with a single form of development. I believe that there are other and more interesting and attractive ways to understand development or to define it. My conclusions, and I think I'm using almost the exact same words as those who have spoken before me. And I think that's wonderful because it's clear that there's consensus and we're taking the same tack. I would say that the important aspect is an expansion of in efforts to reduce social inequalities and structural inequalities, to use clearly an anthropocentric approach, looking at this globally. I really like what Luis Eslava has said about talking about globally local, glocal, not global, but glocal, globally local, to have a thought that is very much localized within the global culture.
Bueno, vamos a continuar entonces con las preguntas a los panelistas. Se nos han formulado también preguntas para el profesor Jordi.
We have some questions for the panelists and for Professor Jordi Jaria in this context. How do you observe from Europe the acknowledgement of nature as a subject of rights within Latin American constitutions?
¿Paso a responder, pues?
Sí, pase a responder.
Bueno, es una responsabilidad inasumible la de Europa en su
Well, it is irresponsible that some countries cannot take on.
como cualquier innovación de este tipo, por supuesto.
As in the case of any innovation, we have several
en el ámbito
views, especially in international law, excuse me, and perhaps from the perspective of environmental constitutional law, there is a certain admiration to the constitutions of Bolivia and Ecuador in this sense, and of course, this clashes with some other elements of hegemonic legal culture, so we could say that it is a more critical view. However, I fear that it is not so different from what may be happening in Latin America. Even though it may be favorable for these perspectives, I believe that outside of Ecuador and Bolivia, part of the literature has been quite critical
opuesta al reconocimiento
opposed to these rights.
No se plantea
as far as I know,
en ningún lugar
in Europe,
there
is no actual trend in that direction. There is a deep link between the cultures of original peoples and the acknowledgement of the rights of nature.
El término y el concepto de derecho es
the concept of law must be adequate to
originaria que se pretende en Europa, obviamente esto
transfer these cultures. In Europe, it doesn't happen, and I believe there is an interest on one hand by academia, also social movements, and we are following what's happening in Ecuador and Bolivia, and we are starting to see what could happen in Chile. The constitutional process in Chile may be extremely interesting, not only at a local level, but also from the perspective of other countries in the planet. There is conflicting experience there in Bolivia and Ecuador, and we have yet to see what will happen in Chile. Both Liliana and Amaya mentioned that should not only include the indigenous narrative, but also gender.
Innovador y desde ese
We
punto de
need to include gender perspective.
Muchísima curiosidad.
And there is a lot of curiosity, but I don't know if this curiosity will be transferred to real decisions from the legal perspective. I think there is a decalage here between the presence or not of these original cultures, and I believe that they offer added value and are a repository of innovation, not only legal, but also cultural, for a society that is somehow disoriented in terms of global change.
Aprovecho de formularte una pregunta que nos hizo
Thank you,
llegar.
Jordi. I'd like to ask a question by Professor Amaya Alves. She's asking, or would like your opinion on whether the constitutional exceptions should guarantee fundamental rights even more.
Yo creo que esto cada vez
I
va a ser
think that this will become
Es decir, yo creo que vamos a
a greater
tender
problem. We will tend to have a more unstable institutional
Este es un debate que yo no
situation. This is a debate that I really didn't want to open or begin because of the possible misunderstandings that may arise. But as Amaya mentioned, the inclusion of eco-feminist perspectives, I think that this question only has a solution or a possible solution if we think about something that we haven't, and we don't have time to do that here, which is to rebuild the idea of fundamental rights. Fundamental rights and human rights are built on a matrix of a dominating subject. There is a patriarchy and there are rights of autonomy that are being debated. So I see that we clearly see the category of rights as
Ahí, por ejemplo, la obra de Ana Grier a mí me parece.
In terms of autonomy, I believe that the works of Laura Grier are very interesting. So from that perspective,
Yo creo que los estados excepcionales que
I believe that the states of exception
deberían de algún modo orientarse justamente hacia esa protección de la vulnerabilidad.
Guide us towards the protection of vulnerabilities, and it would expand the sensitivity of these states of exception. And it could be contradictory to the protection of rights such as autonomy. I find that complex, and that is the main contemporary debate. If we are able to conceive rights as autonomous, and we have images like the protests in Madrid of men with beards opposing confinement, well, we will find our rights being vulnerable. It's not so much, it's more a situation of vulnerability, of protection, of care, and that's where the eco-feminists come in, and it would be part of the political and contemporary debate. Since the state of exception tends towards one direction or another, it will offer us many answers in terms of what we can do with the future of human society.
Paso a formular ahora una.
Thank you, Jordi. I now have a question for Henry Jimenez, also made by Professor Alves. She's asking about the link between international law and internal law in the constitutional process.
Sí.
Sí, no, definitivamente, y siguiendo un poco la doctrina alemana sobre la estatalidad abierta.
Well, following these open societies, I believe that international law, we have different laws, rights. Human rights are part of international conventions where the states have participated, and these must permeate constitutions. For example, international rights. It would be unacceptable today for a state that begins with these international rights conventions to not contemplate in their constitutions this permeation, and it needs to be consistent. The relationship needs to be consistent in terms of the environment, and I am truly convinced of this concept that Amaya has been developing, because we've been working on this for some time in the International Network on Climate Change, Energy, and Human Rights, which Dr. Jorge Palacios forms part of as well. He was the one who ruled in favor in the Colombian case. So we are truly convinced that this relationship needs to be dual. In the South, we see, like Amaya said, we still have many traditions. We still have our roots, which are very important. And unfortunately, Europe has lost them throughout the centuries. They are different stories. They are different moments in history, and we cannot really compare them vis-a-vis. We need to look at them within the historical context. So it's very important, because in human rights and environmental matters, this relationship between international laws can permeate these commitments and the constitutions, more so in the case of Chile in the midst of this constitutional process. Thank you, Henry. I would like to ask yet another question for you, which is, how does the Escazú Agreement contribute to address those cases where there is a risk of environmental damage, especially to help the judges in their roles? Well, this is a very passionate topic for me. Thank you for that question. What I've tried to say in my presentation is that there is a registry and there is information in Latin America. One of the arguments against Escazú is that they say, well, we already have these rules, we have these laws on access to information, on access to participation, and to justice. So that's why it is not specialized. It's not specialized on environmental matters, and it's different in each country. They don't really see the environment as a global issue. And that is where Escazú has a very important role. They see the environmental aspects as a problem of all, not of a single country. That is why special measures are taken, as, for example, in the case of the Ares Agreement, its older brother. It doesn't really have clear and precise rules, as Escazú does, regarding the preventative measures to eventually have a tool for judges to use to stop environmental damage. There's also the right to information. So we as citizens, even before any extractive activity begins that will cause damage to the environment, we can ask for the information. And then with the information, according to Escazú, which is an international treaty, we can go to the competent authorities to demand that we be heard, to demand that we obtain these precautionary measures. That is why Escazú has come to fill this void and to bring joint criteria in order to leave any state with rights that have developed in time and others that have not. That's what we see for Latin America and the Caribbean.
Ahora para Liliana, nos preguntan qué principios ambientales mínimos
Question is, what should be included in that fundamental charter in the new constitution? There are a lot of principles that could be included in the new constitution, I believe we have the classic ones such as precaution. We're talking about the principles of pro natura, all of the things that have to do with participation and access to justice. I would also think about principles that address these challenges of the new knowledge that comes through the traditional knowledge of our indigenous peoples, but that also reflects an acknowledgement of the crisis that we are dealing with, this global crisis. And so therefore the Constitution, it should really reflect, as a matter of principle, interdependence, dependence and interconnection and unity between human beings, nature, and biodiversity. I think that this concept of unity may allow for regulatory development and allow for jurisprudence and case law in complex cases. Legal tradition is very much rooted in evidence. The precautionary principle is assuredly a response to these very often shortcomings rather in evidence with regard to this. So if we could find a principle that recognized this interconnected nature, perhaps a judge in analyzing a specific case could find a greater approximation to the world that surrounds us with a long-term vision.
Que a veces son invisibles. Por ejemplo, la protección de la...
Addressing topics such as biodiversity. Chile has, of course, imported into its country a lot of things that are affecting our native biodiversity. But since biodiversity seems to be such a nebulous topic in terms of the law, it is very hard to get rulings in terms of these, not only threats, but this very real harm. So again, I think we need to use our classic principles, but some innovative ones as well. And I don't know whether this is a principle or an obligation of the state for the future, which is to cooperate more actively with the international community in the search for solutions. Just like in the past, there was a promotion of peace and human rights. Well, our governments need to commit internationally to finding collective solutions to these cross-border issues such as climate change. And for example, the Iguazu agreement, of course, well, there is certainly a topic there. Liliana, let me also take advantage of the opportunity to ask you a question that Mary Kay Lynch has asked, and that is, what is the controversy that exists with regard to the use of the word resource? And specifically in the case of the US, the word resource is important, for example, to address things like oil spills. I think that this is a classic controversy that has to do with not only the use of the word resource, but the idea of sustainable development, and specifically the question of what is development. And based on the discussion that we've had within the network, I can see that there is the word resource is associated with appropriation and things that are subject to appropriation or to ownership, like our mining concessions. So I think it's collective. I think there's some sort of intuition that development and the exploitation of natural resources has led to terrible consequences for people. And we can see what those mining concessions have generated, but there's been no distribution of the harm caused or of the benefits. So resources is immediately associated with property rights and specifically of exploitation per se. Constitutions also encourage culture. They create culture. And the Constitution of 1980, of course, in Chile, has really enshrined the concept of property rights and the ability to have these natural resources owned. So when we talk about the future model that we might have as of a state, well, the idea is to establish principles such as to ensure environmental equilibrium so that we don't have this issue of an extraction-oriented economy. And in Ecuador, in Bolivia, there have been very interesting approaches, but it's not really clear yet what the impact of that protection is. Does that actually protect what Ecuador and Bolivia have done actually protect the environment? Because this understanding of what of these rights and these right holders are, sure, we understand that it is a fundamental right to protection, but the actual impact of that recognition, of that acknowledgement is not clear. And I think there's a concern that we may tend to go in that direction and forget others. And while it's true that what we have in the Constitution of Ecuador, but right next to it, there's our property rights, and those run against the rights of the indigenous peoples. So again, it's not really clear what that formula will be in effective terms. Thank you, Liliana. To conclude, I will give the floor to Professor Winter, who also wanted to refer to the question posed by Mary Kay Lynch. Professor Winter?
Está sin audio.
We can't hear you.
I think Liliana very well expressed concern about the use of the word resource, pointing to the fact that currently the word is used in the context of this is our property. Nature is our property. We can make use of it. We can manipulate it and so on. But this is, if we go back to the Latin origin of the word, is completely wrong. The word comes from the Latin word resurgere. This means to generate oneself again. So if one is used, one has the capability of regeneration. So this word can therefore only be applied to living resources rather than to fossil resources. And of course, it has this meaning, the traditional, the literal meaning, the Latin meaning, opens up new perspectives of protection, Liliana also mentioned. So we need to see to that living resources can exist once they are used. So they should be used only so that they can regenerate themselves. And that is the original meaning, and therefore I'm very much against the current use of resource to just express the possibility of disposal of property, of manipulation.
Okay, thank you very much, Professor Winter.
Thank you very much, Professor. We will, in light of time constraints, now conclude this presentation. It has been very interesting indeed. And now continuing with our schedule, we will begin in just a few more minutes with the next panel, which will be addressing the principles, the environmental principles. Thank you very much to all of our speakers once again. And thank you for your time and for joining us today. And thank you all to all who are following our feeds. We reiterate our gratitude to our speakers on this fourth panel of the forum. We are going to take a 20-minute break and we will come back at 12:25 Chile time. 12:25. We will see you at 12:20. Thank you.